On Monday, the Pretoria High Court declared sections of the Criminal Law, Sexual Offences and Related Matters Amendment Act to be unconstitutional. Lisa Vetten joins us now, research and project consultant in the Faculty of Humanities at UJ. Hello, Lisa.
Hi, John, and good afternoon to your listeners.
What aspects of the Act are unconstitutional, and what are potentially the positives of the declaration and the change in the Act?
Well, the problem is that section of the definition of rape that talks about intent. So in order to be found guilty of rape, you have to show that somebody intended to rape. And the problem has been, and we saw this coming up in the previous Poco case in the Eastern Cape, was that you cannot convict someone of rape if they have the impression that you genuinely do want to have sex with them. No matter how mistaken their belief may be and how irrational it may be, you still cannot convict them if they subjectively believe that you were consenting. So that's what the case has turned around, is this idea of subjectivity, because it allows for all manner of very pernicious myths, such as the idea that if I am wearing a short skirt and you buy me a drink in a bar and I accept it, that must mean I want to have sex with you. And therefore you don't need to bother making any further inquiry into whether or not I genuinely do want to do so. So that's what makes this case important, is it tries to challenge that subjective belief that has allowed, I think, a myriad of misconceptions and stereotypes and inequality, really, in relation to women to being challenged. So that's what's important.
Is it possible in certain circumstances to use that as a defence? I genuinely, and under the circumstances described by my lawyer, I think it is reasonable for me to have believed that the complainant wanted to have, that it was reasonable for me to believe that the complainant wanted to have sex with me. Or is that struck as a defence completely?
No. So I think what is important, there are two slightly different options which were suggested by the court. Firstly, the definition is going to have to go back to Parliament and have to be addressed, either within 18 months or within 24 months, depending on which one Parliament settles for. So the one option was that there should be an objective standard, which would have an element of reasonableness. So the idea would be that if any other person, would objectively have thought that consent was being given, then you could offer that as a defense. The other suggestion is an interesting one. It suggests that, for a definition, until Parliament replaces it with a new definition, that the focus on consent be removed altogether, and instead attention should be paid to coercive circumstances. Can I go into a little bit about why that's important?
Yeah, and tell us
Okay.
which of the two you would opt for were you Parliament, and why?
Sure. I mean, consent is a very tricky notion. And the reason why is that with the very best of intentions, it can, I think, the emphasis on it can unintentionally reinforce a stereotype that women are sexually passive and men are the sexually active partners. So if you retain the focus on consent, it's always the woman who's doing the consenting and the man who is engaging in the asking and the following up. So it continues to keep in place the idea that women are predominantly passive. They give or withhold consent. The other problem with it is that I think many of the rape myths that have been developed have obviously been developed in the context of heterosexual relationships. So we need to be thinking much more broadly around questions of consent, misperceptions and myths in relation to sexual violence that occurs within same-sex relations or between trans people. So there's a need to think much more broadly around how consent would need to take that into account. The other problem, and I'll say this from having worked on some cases where this has been precisely the problem, is that somebody does consent, but they do so because the consequences are simply too awful if they don't. They consent simply to get someone to leave them alone and to stop harassing and bothering them all the time. So this decision may not be of assistance to them at all because they will have looked like they have consented. But the emphasis on coercive circumstances, which is already in our law, is really important because what it says is that the magistrate or judge has to look at the surrounding context in which the act is taking place. And they have to look and see if this is really authentic and meaningful consent that's being given. Or if somebody is just trying to choose the least worst of two horrible options. And I think that is important because it does start to look at things like power imbalances and inequalities that can push somebody into doing something they really would not choose to do were they able to do it. So it places much greater emphasis on looking at circumstances than consent does. And why it's important is it's because it's already written in our law. Our law already says that the courts are required to look at the facts as to whether or not there's been an abuse of power or authority. So, for example, if I suggest that it would help you to get a promotion if you had sex with me, the law does recognize that if that happens, that could be treated as rape because you have abused your position of power or authority over someone's ability to be promoted in order to coerce them into sex. So that's already in our law. I just don't think it's being used well enough.
Lisa Vetten, thank you very much indeed. Lisa is with the University of Johannesburg.